Good morning, everybody. Welcome to the Building Industry Center here in Albany. My name is Gregory Spaun from the law firm of Welby, Brady, and Greenblatt. Today we're going to be talking about bankruptcy on the construction site. What happens when you, as a contractor, get a notice in the mail saying that somebody filed for bankruptcy and you're getting the notice because you're listed as a creditor? Now what? There are going to be a lot of questions. By all means, it's an interactive presentation. If you have any questions, ask along the way. Or you can email me. This has my lifetime guarantee. As long as I'm alive, I will respond to emails. My email is gspaun, G-S-P-A-U-N, at wbgllp.com. And with that, you received the notice of bankruptcy in the mail. Now what? Well, the first question you're going to ask is, who's the debtor? Who's the bankrupt entity or person? That's what you need to know in order to determine what your next steps are going to be. It could be the project owner or developer. It could be your general contractor. It could be a subcontractor. It could be a supplier. There are going to be different reactions depending on who in the construction chain is the one who filed for bankruptcy and now is, the legal term is the debtor of the bankruptcy estate. Well, let's first give you an overview of types of bankruptcy. Chapter 7 is called a liquidation, or sometimes it's termed a straight bankruptcy. Hey, I've got nothing. Here's what I have left. Mr. Trustee or Madam Trustee, you've been appointed to oversee the distribution of the estate. Their job is to marshal those assets and sell them and then distribute the proceeds. The trustee under this model does get a commission depending on what they are able to marshal for the estate, but the pie gets whacked up and sold, and then the trustee distributes based in accordance with priorities. Trustee may also operate the business for a short period of time to wind it down in order to best preserve its assets. The next one's a Chapter 9. It's a municipal bankruptcy. They are very rare. The most recent one was back in 2009 or 10 when the city of Detroit went bankrupt. But they're rare, just something to keep in mind. Chapter 13, that's a personal bankruptcy. What a person does is typically they enter into a 3 to 5 year repayment plan based on what their income's going to be. So their creditors get paid a little bit and then the rest gets discharged. That's only important in the construction context when there's a personal guarantee of some kind of an obligation, and the person who's putting their business into bankruptcy doesn't want the obligation following them. So chiefly, we're going to be talking about Chapter 11s, reorganization, restructuring. Those are the ones where a company will emerge from bankruptcy. Okay, they go through this process. It's much like doing intensive workouts. They get slimmer, they get stronger. So the theory goes they get that fresh start, and they can come up and pick up more or less where they left off without the burdens of debts that they can no longer handle. So accordingly, it's a reduction or restructuring of the debts. It's not a discharge. There's also no trustee appointed. The debtor remains in possession of its assets. And if you've ever heard the term DIP loan, that's a debtor-in-possession loan by a lender to a bankrupt business in order to give them the funds to go through the bankruptcy. The debtor-in-possession operates a business, but it's under court supervision. You don't have the freedom of, hey, this is my business and I'm going to do what I want. You have the court now looking over your shoulder, giving you guidelines as to how you need to operate that business. While there's generally no trustee, there may be a trustee appointed where there's some allegation, credible allegation that there was some fraud, dishonesty, incompetence, or a gross mismanagement. Now, it's easy to think, well, of course there's a gross mismanagement. They went into bankruptcy. Look, it happens to any business. Again, it can be a domino effect where you get caught up in a black hole, as it were, and you just can't escape because you don't have the resources to be able to do so. So those companies don't get trustees as a matter of course. It's where there's something additional, something that drove them into bankruptcy more so than getting sucked up into something. So now let's talk about bankruptcies generally. What you do is you file the bankruptcy petition. That's what starts the bankruptcy. Now there are pros and cons to filing a bankruptcy petition. The pros are you get the benefit of the automatic stay found at 11 U.S. Code 362. What that does is that stops all collection actions against the debtor. Foreclosures, evictions, lawsuits, judgment enforcement. All of that has to stop immediately. Now, as a practical matter, sometimes somebody doesn't get a notice. We'll talk about that shortly. But all collection action stops at that moment. The debtor has the option to get out of burdensome contracts it could not successfully renegotiate. Again, you've got a lender who's knocking on your door, and like, look, I know I got 6 years left on the note. If I can finance it over to 10, the payment goes down. I know I'll pay more interest, but I can swing a lower payment over more time. And the lender's like, no, we're not doing that. Well, once you file a bankruptcy petition, you can then say, okay, I'm getting out of that contract. Similarly, with supply contracts or with other types of contracts, you can similarly get out of those. Importantly, in a bankruptcy context, the estate can recover payments made within the 90 days before filing. What they're termed under the bankruptcy code as preference payments. It's assumed that a payment made within 90 days of the bankruptcy was made to preferred creditors to the exclusion of others. So what a trustee will do, or what a debtor-in-possession will do, is they will claw back so that they can be redistributed under court supervision as a part of a plan. And what the bankruptcy does is it sheds and restructures debt in an orderly fashion. It's not left to the vagaries of, who gets a judgment first, who gets to the sheriff or the marshal first, and who has the wherewithal to find a bank account or some other asset. It's done in an orderly fashion in order to give the debtor a fresh start. Now, what are the cons of filing a bankruptcy petition? The court will supervise the operations of your business. Again, you lose the freedom to operate your business as you see fit. You have the damage to your business reputation and your credit. Again, you're filing for bankruptcy. That's going to affect who's going to want to do business with you in the future. Now, I can easily make the argument with the fresh start and also the fact that a creditor a debtor cannot refile for a bankruptcy within 6 years of a discharge or a confirmed plan. They're actually a better person to lend to. One, you will charge a little more interest for the higher risk, and two, they can't redischarge. So you've got 6 years where you've got them on the hook. So again, while there is the damage to the business reputation, again, I can make a counter argument that that's not as bad as it seems. And there's an expense. Believe it or not, bankruptcy is not cheap. Everything costs money, and unfortunately, shepherding a business through the labyrinthine bankruptcy code, it gets pricey. And again, personally guaranteed debts are not discharged unless there's a concurrent personal bankruptcy, a Chapter 13 that I referenced earlier. Now what happens? Okay, I'm filing the petition. I know what the cons are. I know what the pros are. The pros outweigh the cons, so let's make the filing. Well, an estate is created. It's not much different than an estate when somebody passes. It's a legal entity that marshals assets for distribution. Your creditors get classified by priority. Not everybody takes an equal slice of the bankruptcy pie. Your first slice are your secured claims. They're guaranteed by a collateral or a lien on a property. Your mortgage lender, in a personal situation, because they have a mortgage on your house, they can then foreclose on the home. There are some steps they have to take, but they're not left at the bottom of the pile with Visa and MasterCard, who often take a nickel on the dollar. Similarly, in a construction context, a mechanic's lien is a lien on property that will make you a secured creditor. Now, I did say that you can't take any steps to enforce your a payment obligation against a debtor. That being said, if you're a contractor, you've performed work, you can perfect any lien that you need to. You can file the mechanics lien. You just can't foreclose it because that'll be taken care of during the bankruptcy process. But you can file the lien, plant your flag proverbially, and make yourself a secured creditor. If the property is underwater, the claim may be partially unsecured. You have a property worth $5 million, and between the mortgage and the mechanics liens, there's $8 million amongst you. Okay, well, somebody's taking a haircut. The haircut is on the unsecured portion. After your secured claims, there are unsecured priority claims. They're paid after the secured claims, but ahead of your general creditors. These are your administrative expenses of the bankruptcy, your legal fees and whatnot. These are also your employee claims, your wage claims, your union claims, taxes, render unto Caesar what is Caesar's, your bondholders, and then you have your unsecured creditors. This is everybody else. In a personal bankruptcy, it's Visa and MasterCard. In a commercial, it's just contracts you've signed without any security interest. There's no UCC1. It's just, hey, here's my signature. Keep in mind that in every construction contract, and I still see it, I reviewed a contract yesterday and it's there, there's something called an ipso facto clause. Basically, hey, we can default you if you file for bankruptcy or for protection under any state or federal statute that protects debtors against their creditors. Well, those are all per se illegal. No court will enforce them, but they're there. So if you're in the process of negotiating a contract, strike it, negotiate it back in, you're giving somebody ice in the winter. So let's talk about the automatic stay. This is the big number one benefit of a bankruptcy, and this is why a lot of people rush to the proverbial courthouse. Of course, the courthouse is now electronic, and it can be done from the comfort of your bathrobe in the middle of the night. But again, once upon a time there was the race to the courthouse. There's still a virtual race in order to get the benefit of that automatic stay. It comes into effect at the moment of filing. And it's effective regardless of whether you have notice of the filing. Again, if you've ever had the unpleasant experience of having a debt collector reach out to you, by mail, email, or phone, they will advise you that anything we do here is to collect a debt. However, if you've filed for bankruptcy of which we have no notice, then please just consider this informational. Because again, they know that there's no enforcement rights as to there, and what they're trying to do is stave off any claim of a willful violation of the automatic stay. Because if you know about the automatic stay and you still undertake enforcement action, that will result in sanctions by the court. It's extremely broad and it ceases all collection activity. There are exceptions, acts to perfect liens. You can file your mechanics lien, but you can't prosecute it. You can't foreclose the lien. Similarly, if there's an enforcement of a health or safety law, that's something for obvious reasons why it's an exception in the code. The idea is to give the debtor a fresh start, not give the debtor carte blanche to disregard public safety. There are also criminal statutes. They're an exception. Now, I mention this in the context, speaking to you contractors in the room, because New York has a criminal statute that's applicable to contractors. Article 3A of the lien law provides that any funds received by it from an owner to a general contractor and an upstream sub, they're trust funds to be held in trust until all claims of laborers, suppliers, subcontractors, etc. have been fully paid. Until those claims are fully paid, you're obligated to maintain those trust funds, and if you don't, if you consent to the diversion of trust funds for a non-trust purpose, that's a larceny. That's a criminal statute. So, again, there are contractors who will say, well, it's nice that you're in bankruptcy, but you diverted trust funds. Your bankruptcy is not going to stop the DA from chasing you. So, again, you want to consider whether there's a trust fund diversion. Maybe you want to bring that to the attention of your debtor. So, how do you get relief from the automatic stay? Okay, I've got a mortgage. I want to foreclose it against the property. The debtor's not going to be able to pay off the property, so I want to keep going with that foreclosure. You basically file a motion, which is a request to the court to continue certain collection actions. In doing so, you have the burden to show that your interest in the property is not going to be adequately protected. Hey, the property's underwater. The debtor has no incentive to preserve it, so let me continue my enforcement action, my foreclosure, in order to preserve the asset because the debtor is no longer in a position to do so. Debtor has no equity in the property, and the property is not needed for the reorganization under the Chapter 11 plan. The burden then shifts to the debtor to show that the stay is necessary and that the moving party's interest, the creditor's interest, will not be impacted by the continuation of the stay. That's not an easy burden, but again, it's possible. The stay lasts for the entire duration of the bankruptcy unless the case is dismissed, unless the stay is lifted, or the discharge is granted. At one of those three moments, it's game on again. Now, a lot of your contracts have arbitration clauses, so let's talk about that. Arbitration clauses, they're great. You typically have a more knowledgeable finder of fact. It's often a construction attorney. Sometimes it's an architect or an engineer, a construction manager, somebody who knows the industry, as opposed to a judge who's sitting on a court with broad jurisdiction, or 6 people who, while well-meaning, they couldn't think up of an excuse to get off of jury duty. So, again, these are the people who they often are. It's a less formal process. It's a less cumbersome process. It tends to be a little cheaper. You don't have any right of appeal or review. That's kind of the trade-off. But it tends to be cheaper and quicker. And importantly, you waive your right to a trial by a judge or a jury. But you can't be compelled to arbitrate in the absence of a pre-existing agreement. Now, that agreement doesn't need to be explicit. You can accept the benefits of a contract where there's an arbitration clause. But, again, in the absence of that circumstance, you can't be compelled. Now, an arbitration clause, is it enforceable in bankruptcy? Or do you have to now go to bankruptcy court to litigate your claim? Well, the Federal Arbitration Act declares a national policy favoring arbitration. For the simple reason is every case in arbitration is one less case clogging up some judge's docket. It keeps the courts are very busy, the dockets are very clogged. So the courts want as many diverted into an alternative dispute resolution procedure, ADR, such as arbitration. The federal appellate courts hold that the bankruptcy law doesn't trump the Arbitration Act, but courts are to enforce agreements unless it would seriously affect and jeopardize the goals of the bankruptcy. So again, typically there's going to be an examination as to the impact of the arbitration and whether it would impact the bankruptcy code. Courts make that determination, and the term of art is whether it's a core proceeding. Does the claim in arbitration affect the substantive rights of the debtor in the bankruptcy, or is it just an ancillary case that happened to get dragged in? Arbitrations will be enforced in non-core proceedings, and they may or may not be enforced in core proceedings. Courts are all over the place. New York federal courts generally will, but not universally. Okay, now let's talk about the question I asked at the outset. Who's your bankrupt? Owner bankruptcy. This is your greatest potential for a domino effect. Again, the owner doesn't pay the GC is not paying its subs down to its suppliers. Depending on how much you have tied up in that job, it can easily domino effect to you. So what are the bullets you want to dodge at the beginning? Your pre-filing issues. These are what you want to consider before you pull that trigger. You want to try to negotiate with your secured lenders. Hey, I'm going to be filing for bankruptcy. I've retained bankruptcy counsel. Let's talk about avoiding that. Sometimes a lender will say, oh, you're threatening bankruptcy? A lot of times it's an empty threat. They'll try to call a bluff. Okay, but sometimes the bluff does get called. But if it's a credible threat of bankruptcy, that may drive a lender to compromise where they otherwise wouldn't have. And again, the bankruptcy ceases the collection effort. Now, you also want to consider what are considered exempt versus non-exempt assets. Now, this is determined by state law, even though you're dealing with in federal bankruptcy court with the Federal Bankruptcy Code. The code defers to states. This is why O.J. Simpson could keep a multi-million-dollar mansion in Florida despite having judgments against him. Florida has an unlimited homestead exemption, so that would be an exempt asset. New York does have a homestead exemption, but there are limits to it. Again, it's state by state. The exempt assets are exempt, obviously, and can be kept by the debtor, and it's defined by state law. If you're seriously considering bankruptcy, what a lot of debtors will try is converting non-exempt to exempt assets. Putting money into an exempt asset such as a house, paying off a mortgage, so that now you don't have that obligation. But again, it's the unlimited homestead exemption. Again, using Florida as an example. You may want to pay taxes and personally guaranteed obligations before filing, because those are going to have ramifications down the line. Again, you want to pay personally guaranteed obligations because they're not going to go away in the bankruptcy. So you want to keep that in mind, and keep in mind preference payments, that 90-day window. If you're going to make payments in order to try to recharacterize, deal with bankruptcy priorities and recharacterize assets, you've got to do it before 90 days before the bankruptcy. Payments to outsiders of the bankruptcy estate, they get a 90-day look back. Again, you want to pay a supply house you always do business with, and you want to do business with on the other side. You want to make that supplier happy, content enough that despite the bankruptcy, they will continue to do business with you. So you probably want to come current with them more than 90 days in advance. If the payment's to an insider, hey, one of our officers loaned the company money, so we want to pay them back before the 90 days. Well, insiders, the look back is a full year. Again, it's to try to prevent somebody from making a preference payment to somebody who has intimate knowledge that the bankruptcy is coming. And debtors have a desire to avoid a payment being recouped as a preference, and it may necessitate a delay in the bankruptcy petition filing. Again, the owner knowing about the bankruptcy will affect their judgment in who they're going to pay and when, particularly if they're aware of the 90-day preference window. Many states have fraudulent conveyance laws that permit a creditor to set aside such an attempt to skirt. New York has a debtor-creditor law, sections 270 through 281, which permit such conveyances designed to dodge a judgment from being, you can have them set aside. The preference payment statute in the bankruptcy is an analog. And if you're what you don't want to do is you don't want to give a trustee a war chest to start digging on through your books, through your payment histories, through your business, and potentially turn your own money on you. Other pre-filing issues, the Bankruptcy Code permits you to shed and jettison burdensome debt, but you can also preserve an important contract. You have a lease, you want to continue to operate out of that facility. You don't want that landlord to say, "Hey, you're bankrupt now. I'm gonna call the real estate agent tomorrow." The debtor has the right to assume and retain contracts, but it can't do it with a contract that's been properly terminated before the petition. So the filing is used to preserve the contract. Again, you're in the middle of a foreclosure proceeding. The eviction's coming. You want to preserve the lease. Okay, you file for bankruptcy before you're evicted. That will preserve the lease, and now you deal with it in the course of the bankruptcy. And what you owe pre-petition rent, that gets paid at a certain point, but you want to assume that contract going forward. But again, you can't give CPR to a dead contract. Once a contract's terminated, it's terminated. You're not getting it back. So you have to act before the contract is terminated. Again, on the other side, if you can't renegotiate a bad contract, you can pull the plug on it. Okay, we're done. We're walking away. And again, if a contract expires by its own terms, it can't be resuscitated. It can't be extended. Once it's dead, it's dead. So the contract has to be what's called executory. Performance hasn't been completed in order for a debtor to accept it or reject it. The deadline is 60 days within the filing of a petition, or you can move to extend the period by making a motion to the court. Once the period's gone, it's gone. Now, what's an executory versus a non-executory contract? Executory contracts, quite simply, they're just not complete. There's still obligations. In a construction context, courts use substantial completion of a project as a measure to determine executory versus non-executory. If you've substantially completed, you've substantially performed your contract, and the rest is just wrap up. An owner may attempt to characterize a contract as non-executory in order to avoid the contractor, the debtor, from assuming the contract. Oh, good, he's pulling a plug. We can again, release the premises or whatnot. Actually, that's a bad example because occupancy keeps the contract executory. But my point is that by characterizing the contract as non-executory, now there's a fight to be had as to whether the debtor can assume the contract. Now, labor contracts. These are contracts like any other contract, in theory. There are specific provisions that in the code and in case law relating to how special these type of contracts are. They can be modified by a bankruptcy court, but the debtor is under an obligation to first negotiate with the union about modifications. The negotiations have to be in good faith. Take it or leave it offers are typically not. And if there is a legitimate impasse, then the debtor may seek modification through the court after negotiation. And again, both sides have to negotiate in good faith. The union can't take a hell no, we won't go line, the same way the debtor can't take the, take it or leave it line. The court can impose a unilateral modification on the union, but only if a modification was rejected in bad faith and overall a balance of the equities. Again, the union's representing its workers. There are equities of individuals involved. So if the balance of those equities favors modification, your collective bargaining agreement can be modified. If the debtor wishes to short-circuit the process, again, in the context of a bankruptcy where a debtor is hemorrhaging money, time can easily be of the essence. So the debtor may seek to short-circuit the process and demonstrate that the modification is essential to avoid irreparable damage. You'll get a hearing in bankruptcy court on that issue. Now, trust fund issues. I did mention about Article 3A of New York's lien law. Generally, monies in the possession of the debtor or accounts receivable are property of the debtor and become property of the estate. Anything the debtor owns is the property. Here's the specific language. I'm not going to quote the whole thing, but it basically says everything goes to the debtor only to the extent of the debtor's legal title in the property, but not the equitable interest. When you get paid but you owe a subcontractor money, you have legal title in that money, but the equitable right to that money goes as trust funds, flows downstream to your subcontractor, ultimately the laborers, the suppliers, etc. That's the crucial language. That means it's not property of the estate. In a contractor's Chapter 11 bankruptcy, prepare to make a motion to oppose. Prepare to oppose any motion to use cash collateral. I've done this several times. One of the most fun days I've ever had in court was advising a bankruptcy judge of the nature of Article 3A of the lien law, and that the lien law considers any consent to the application of trust funds for a non-trust purpose as a diversion of trust funds and therefore larceny. While I didn't directly accuse the judge of being complicit in a crime, I did explain that these are trust funds and, technically while Your Honor may be acting in good faith and whatnot, you're consenting to the application of trust funds for a non-trust purpose, the general operation of the debtor's business. Yeah, that was a hearing where before the hearing I was hearing scuttlebutt in the back of the courtroom about some rogue contractors getting in our way, and as we walked out, the rogue contractor who I was representing had the appointment of a court-appointed monitor to determine what were trust funds and what were not. The court indicated it would grant the motion to non-trust funds, but trust funds would be segregated. So my client's rights to that money were preserved, and the rogue creditor prevailed. So again, when you're examining for a trust fund diversion, you want to see if a general contractor has paid for a subcontractor's scope of work, but that money has not flowed down. There is the ability of a contractor to use monies for the overall cost of improvement. Look, just because you're the electrician, and perhaps your upstream contractor, your GC, likes the plumber a little bit better, paid the plumber but didn't pay you, well, they're both a cost of improvement. There's no requirement that the money specifically flow down. But it's a good indication if that line item in a schedule of values has been paid but hasn't been flowed down, okay, there's been an application of trust fund. Was it to a trust purpose or not? Again, if it was paid to the plumber, yes, that's a trust purpose. If it went to buy a boat for the contractor, that's a non-trust purpose. So let's talk about progress payments and retainage. A lot of times when there's trouble on the horizon, a contractor or upstream sub will issue a joint check. If it's earmarked for a specific subcontractor, it's said to pass through the debtor, and it's not subject to recoupment. Again, the debtor will have bare legal title, and it's just going to pass through because it's meant for that specific subcontractor. But simple joint checks or simple endorsed over checks, they're not sufficient to pass through. So if you're making a joint check to somebody you have significant financial concerns about, put in the memo line, electrician, or something indicating where that is to go. Simply making a joint check, not enough. Frequently, the preference payments are the subject of claims between various sureties, lenders, subcontractors, and suppliers, and they'll get litigated in the course of the bankruptcy. And that litigation will determine whether they're preferences, whether they're property of the estate, and then basically what's in the pie that will ultimately get whacked up. And often the debtor's not even a party to that litigation. It's the debtor knows what the pie is going to be, and everybody's just fighting over how it's going to get whacked up. Bonds. Now, this is an issue that obviously if you're a subcontractor, your GC has a bond. Hey, I don't need to worry about the bankruptcy. I've got a payment bond. These provide that the principal are jointly and severally liable. So if you have a payment bond claim, a lot of times the unpaid contractor will sue both the GC and the surety. You don't have to sue both. You can sue one or the other or both. If I want to keep a case streamlined, I'm not going to sue the contractor, particularly if they're in bankruptcy. If they're in bankruptcy, I can't sue the contractor. I can just file a proof of claim in the bankruptcy. But I can sue the surety. What the surety is going to try like hell to do, they're going to try like hell to bring it into the context of the bankruptcy. In order to do that, they have to allege that it's basically a core proceeding. And what they're looking to do is they're looking to get the aura of the automatic stay applied to them. Okay, let's litigate this in bankruptcy court. There are going to be delays. It's going to be considered by the judge as an overall part of the bankruptcy. And that's not the purpose of a bond, but this is what often happens, unfortunately. And again, once you're in court, the claim against the surety gets delayed, and it often just gets resolved out of bankruptcy proceeds. So again, the purpose of the bond is to secure payment, and if you're going to bankruptcy court anyway, then what's the point? This is an issue that the industry is going to have to continue to fight, unfortunately, in bankruptcy court, in order to get a judge to say, no, this is a joint and several obligation. You go over there. You go to state court. And a surety that pays on a bond claim, they have a Visa or MasterCard or American Express type claim. It's general unsecured. That's what they're looking to avoid. They're looking to avoid having to pay you and then taking nickels on a dollar. No surety makes money by paying claims. So the discharge. There are times when it will be denied. So when will that happen? Well, first there's a non-dischargeable debt. It's a debt that's incurred by false pretenses, fraud, defalcation, larceny, or a willful or malicious injury. As a matter of public policy, if you're accruing debts in this manner, you shouldn't get a fresh start. It should go without saying. So there's a logic behind that. Now, there are also situations where the debtor is denied a discharge. Here, if you have one obligation that's incurred by one of these reasons, the affected creditor will move to deny the discharge as to that debt, and that'll be litigated. However, where we're dealing with pervasive issues, the motion is to deny the discharge, and that's not just limited to one debt. That's limited to the entire bankruptcy proceeding. The result of this is a dismissal of the bankruptcy proceeding, and the debtor's thrown to the wolves. Now, there are obviously higher grounds for denying a discharge overall, but you've hidden, destroyed, or failed to keep records or of your assets or your financial affairs. You've lied or you've tried to defraud the court or a swath of your creditors. You have failed to explain the loss of any assets. I don't know where it went. Well, you're operating a business. You should know. That's when the discharge will overall be denied. So with that, I hope I've given you enough information to know that when you get that notice in the mail, you do have rights, and that you're not going to be out of luck. And depending on what you do, you may be able to preserve your status as a secured creditor and not end up with nickels on the dollar. So if there are any questions in the room, failing that, again, if you come up with questions later or anybody who's watching this on a subsequent video, my email is gspaun, Gspaun, @wbgllp.com. Well, thank you all for attending.